Hello and welcome to this edition of Inside Judicial Watch. I'm your host, Jerry Dunleavy. Today, we're going to be discussing the tale of two investigations, the Clinton email investigation and the Trump-Russia investigation, and the double standard that exists between the two of them. The way that the Obama Justice Department and FBI conducted its investigation to Hillary Clinton, where they seemed to be doing everything that they could to avoid prosecutions, versus Special Counsel Robert Mueller's investigation, where he seems to be going all out in his investigation into Donald Trump. Kid gloves versus bare knuckle tactics, leniency versus hardball. These are sort of the distinctions that exist between the two of them, and we're going to do a bit of a deep dive on that. And helping lend her expertise and helping inform our viewers what Judicial Watch has uncovered in regards to both these investigations is Judicial Watch Senior Attorney Ramona Coca. So thank you very much for joining me today, Ramona.
Thanks, Jerry.
So as we go about comparing the two of these investigations, and I think it's important because fairness and perception and all of these things really do matter, especially when we're doing major investigations like this. So if we could start, talk a little bit about the genesis of the Clinton email investigation, kind of how it came to be and the role that Judicial Watch played in sort of uncovering that scandal.
Sure, and I'll try to be brief because
Yeah.
it's we're talking about the last 6 years.
Yeah.
So the genesis really of that investigation began with the Benghazi attacks on September 11, 2012. And Judicial Watch, my opinion, and having worked on these matters, I believe Judicial Watch was at the center from the beginning of these investigations, of this investigation and the Benghazi attacks. And the reason that was, you had the administration, the Obama administration, who came out putting out a false narrative with respect to what happened when the U.S. consulate was attacked in Benghazi, when we lost an ambassador and 3 other American citizens in the attacks, and blaming a false YouTube video, or blaming a YouTube video falsely for the attacks in Benghazi. Judicial Watch filed numerous FOIA requests, submitted numerous FOIA requests with the State Department and other components as well, and other agencies. Through the agencies did not cooperate with our requests, and just for our viewers, these are under the Freedom of Information Act, basically asking for federal records and information that the government has. The public has a right to know what its government is doing, so it's under what for short we call FOIA. So it's under FOIA that we litigated a number of cases, trying to understand what really happened. Very quickly, we learned in our investigation that the narrative, the YouTube video narrative, was false. And also we had uncovered emails that the State Department had not provided to Congress, where what has been referred to as the Ben Rhodes email, just basically outlining and showing that the White House was in coordination with the State Department, trying to underlie the fact that, or telling people to say that it was the YouTube video that was at fault. It wasn't the policies of the administration. It was not a pre-planned attack.
Right.
And we also had records that we uncovered where showing that from the beginning, from at midnight, on the day that this was happening in Benghazi, the government knew that this was a pre-planned attack by the type of arms that they used, the way that it was coordinated, the way that the consulate was attacked. We knew that it was a pre-planned attack. And it wasn't some spontaneous protest, out of a protest that was happening, that the crowd went awry and turned violent.
So the genesis here, it starts with the sort of the misleading statements about Benghazi, the Obama White House, Ben Rhodes, working with the State Department to sort of come up with this narrative where Judicial Watch uncovers emails showing that the talking points that Ben Rhodes and others at the White House were putting together were false, because it was actually known on the night of the attack that this was a terrorist attack, Al-Qaeda-like elements involved, and that sort of thing. So Judicial Watch uncovers sort of this sort of deception from the Obama administration, from Hillary Clinton's State Department, and we find this through emails that we're uncovering.
Correct.
So how does that turn into an investigation into Hillary Clinton's email practices?
Well, I'll tell you. In the case that we had, one specific case that we had, we requested talking points that were provided to then U.S. Ambassador for the UN, Susan Rice. The talking points that were provided, as you recall, she went on to the Sunday talk show host and talked about that. She was questioned about the Benghazi attacks, and that's when this YouTube false narrative really picked up speed and a lot of attention from within the government. Actually, I think there were some records showing that they were shocked by individuals within the government of where is this narrative coming from, based on the evidence that we have. So in that particular case that we had asking for talking points, that was and that was filed in 2013. The request was sent out right after the attack. That was where we recovered the Ben Rhodes email. The Benghazi Select Committee, as a result of the email we uncovered, was formed. We settled that case once we recovered that email. We had enough information that we got from there. But in part of our discussions here internally within Judicial Watch, one of the things we wondered are, where are Hillary Clinton's emails on any of this? So we had emails from Cheryl Mills, we had emails with Susan Rice, but we had nothing from Secretary Clinton. So immediately upon dismissing that case, we filed another FOIA. We submitted another FOIA request asking specifically from then Secretary Clinton's office for any emails relating to the Benghazi attacks and the talking points that were provided to Susan Rice. That case immediately followed and was filed in 2014, well before the revelation of the private server and the emails that came out in 2015. So we filed that lawsuit, and we were provided pretty much the same documents that we were provided in the previous case. In speaking with the State Department's attorneys at the Department of Justice, we asked them, we said, okay, if these are all the records, why don't you provide to us before we go ahead and what we call summary judgment motions, before we go to the judge and asking the judge to rule and see if there was a sufficient search. We asked them, can you provide a draft declaration and see if you did a sufficient search or not? And based on that, we'll decide whether we want to move forward with summary judgment. Do we think that the information is sufficient that the State Department has provided? And if so, we'll go ahead and, we think it's sufficient. If not, though, we'll go ahead and move forward with summary judgment. That was in December of 2014. We were provided a draft search declaration. Or we requested a draft search declaration. Within about, later, I want to say within a few weeks or the next following month, we are informed that the State Department is conducting another review of some emails, which is what we were told. They did not specify with respect to what emails they were searching that still need to be searched. And so let's push this back with respect to the draft search declaration. And this was filed also as a status report in our case, and the case was and is still currently pending in front of Judge Lamberth. This is in February of 2015. Our search declaration is shortly due after that. On March 2nd of 2015 is when the New York Times article comes out that there was a private server that Secretary Clinton used an outside email account exclusively for all of her State Department communications and her work communications. So that is why I say Judicial Watch was really at the center of this investigation, and what led to it coming out and making the making daylight light of day.
Right.
With respect to her email use for her State Department work.
And so it's revealed because of Judicial Watch's various investigations that she's actually got this private email server that she's conducting all of her business on.
Right.
Now, that's kind of the genesis of the Clinton email investigation. It sort of jumps off from there. Now, the Trump-Russia investigation, if we want to call it that, kind of has a sort of two different jumping points. One segment of it starts with sort of the Clinton DNC-funded dossier and that sort of thing, kicking things off. And then sort of another version of it is kicked off by Comey and pushing for a special counsel. So kind of talk with me about sort of those two different things and how that's different than how the Clinton email investigation got its start.
Okay, so let me just back up and finish my last statement with respect to the Clinton investigation. This is how the information came to light.
Yeah.
Once this information came to light, then we had many other filings against the State Department that related to her emails, and one in particular in front of Judge Sullivan that we had previously dismissed, and we filed a motion asking for the court to reopen it based on this revelation. And there we indeed conducted an investigation through discovery. It's a legal term. Basically, lawyers get to ask questions either under oath, orally, or in writing as a form of interrogatory of witnesses. And the scope of that investigation was the creation and use of the email server and its purpose. And that's when we deposed Secretary Clinton's advisors, including Cheryl Mills, Humel Abedin, and other senior State Department officials. So that's what led to the investigation. So, and then we'll talk about it more with respect to the comparison.
Absolutely.
Now, jumping back now to your question with respect to the
sort of the genesis of the Trump-Russia investigation. What sort of kicked that off?
Well, I guess the dossier obviously had a component in it, but I really like to focus on Director Comey's role in it, because I think his role was so central to also the Clinton investigation, as well as kicking off the special counsel Mueller's investigation.
Yeah.
And Director Comey, as we know, I believe it was February or March, the time frame I'm a little of last year.
When he was let go.
When he was let go, and then he leaked information with respect to his personal, individuals have called them personal notes. I dispute that they're personal when you're taking them within the scope of your job.
Right.
With his notes with President Trump, and leaked them. And he even testified that he did so with the purpose of the appointment of a special counsel at the time.
So that's kind of a very different sort of way that investigation sort of jumped off. Sort of the personal intervention of former FBI Director Comey, taking those memos, leaking them to the press, and then, like you said, even testifying that he did that because he wanted there to be a special counsel. So it seems like if he wants there to be a special counsel, he is very serious about this investigation. So let's jump back then to the Clinton email investigation and talk about the level of seriousness or lack thereof that the FBI and DOJ brought to that investigation. So Judicial Watch, our work, and then sort of investigations by other outside groups, really the FBI starts to look into this, right? And talk with me about how they start to handle it. I mean, what was their What was their tact?
Well, I mean, there's striking differences between the two approaches that were taken.
Yeah.
With respect to the Clinton investigation, you had immunity deals that were handed out left and right to central figures who were part of subject matters of the investigation. And you also had, and I don't know if you want to go into further discussion about the immunity deals or not, but
Yeah.
Cheryl Mills, Brian Pagliano, who was the IT technician or employee at the State Department, who helped set up the server, who did the whole thing, and he was handed an immunity deal. We actually deposed Brian Pagliano, and he asserted his Fifth Amendment right to every single question of our deposition.
So in an investigation into Hillary Clinton's, private email server use, key players like the IT guy who was in charge of handling it were given immunity deals from the FBI?
Yeah, from the DOJ.
From the DOJ.
Yes.
Cheryl Mills, she was the...
She was counselor to the Secretary of State and her chief of staff at the Secretary, during her tenure as Secretary of State for Hillary Clinton. The immunity deals are very interesting from what's been reported with respect to Cheryl Mills, and I believe as well as Huma Abedin. And I think it will be interesting to see the FBI's approach to both of these investigations when we look at how they are making requests for records, making requests for evidence, and seizing them. With respect to the Clinton investigation, they coordinate and plan ahead. Where shall we meet? And for us to be able to pick up devices that Secretary Clinton had used or where her emails may still be stored on. Heather Samuelson, David Kendall, Hillary Clinton's personal attorneys were involved in that. Devices were handed over, and devices were also not handed over. And the FBI knew that. The FBI was told, we don't have these anymore. Did the FBI go ahead and ask them, where did you search? Where were they? Did the FBI go ahead and hand out a search warrant for any of these devices? The answer is no. With respect to special counsel's investigation, you have search warrants and you have attorney of the president whose office and hotel room are raided, subject to a search warrant. Both Hillary Clinton's associates and camp, as well as President Trump's attorneys, have said that both camps are cooperating with the investigators. But yet the way that these camps are treated are very different.
Very different. Because, like you said, it was known that there was information that was missing from what Hillary Clinton was handing over in the investigation. They knew that there were emails that were missing, there were devices that were not there, but there were no raids conducted. There were no real physical searches or physical seizures of anything that ever really happened. Okay, so let's talk a little bit more about the conduct of the Clinton email investigation and continue to kind of connect it to sort of the very serious, strong hardball tactics that Mueller's taking and sort of compare it back. So the exonerating statement that was apparently drafted by Comey and those working for him in relation to the Clinton investigation. I believe that was done before even important interviews were.
I believe
held.
That's right. I believe it was. We know it was definitely done before Secretary Clinton was herself interviewed, and I believe it was done before Cheryl Mills, who I think is a central figure in that investigation, and it was done before her interview with the FBI. And the reason why I say that Cheryl Mills, I believe, is a central figure in that investigation is because in another FOIA lawsuit that Judicial Watch filed against the State Department, we had uncovered that Secretary Clinton had made numerous requests to the State Department for secure BlackBerry devices and smartphones, including for iPad devices. And Cheryl Mills was the person in charge and who took lead of making those requests to Department of State employees. The Department of State officials evaluated the request and came back and said, unfortunately, we cannot do this. These are the associated risks, security risks, very serious concerns with respect to security of the Secretary's well-being, as well as national security, and also the contents of whatever communications may be in there, that the requests were denied. That was drafted very nicely and neatly, and we have a copy of this that we've posted on our website, which was provided in a memo to Cheryl Mills. That was done before Secretary Clinton had attained several of her iPhones and several of her phones that she had used. And also during the entire time that she used this private server, knowing that it was not going and it was not going through any of the State Department channels, and understanding. And Cheryl Mills responded back to the DS officials saying, we understand the risk concerns.
So not only was Hillary Clinton's server, obviously was done illicitly, privately, these devices that she was using improperly, but they had actually been told, no, don't do this. This is risky. This is bad. So not only is this some, sort of off the books and that sort of thing, but they'd also been warned about the risks.
Absolutely. And they responded that they understand the risks, and yet they did it anyway.
Okay. So when the FBI is investigating all of this, they do an exonerating statement early, that sort of thing. What is kind of driving them? I mean, FBI Director Comey was obviously in charge of the investigation, but there was also influence, it seemed, from other officials in the Obama administration, like AG Lynch, Loretta Lynch, the Attorney General. So can you kind of talk a little bit about what might have been sort of their influence or interference or what have you in that investigation?
Again, it's whatever the narrative the administration wanted to pass along. It started with Benghazi, it was a false narrative. And now again, we had the Attorney General, Loretta Lynch, and as well as the Clinton camp itself, and by camp I mean her close associates, who wanted to change the narrative, first asking for this investigation, the FBI investigation, not to be called as an investigation, but rather as a matter. Also not to be called as a criminal investigation, but rather a security investigation. What is a security investigation? And I believe, as Director Comey said himself, the FBI investigates criminal matters and criminal investigations. That's what it does. So trying to pass on this narrative that the FBI is actually doing something not that the FBI is charged to do as an agency just tells me at least the desperation of trying to really twist the narrative of what was happening. If we look at what's going on now with Special Counsel and the Mueller investigation, nobody's calling this a matter. Nobody's calling this, some not so serious investigation. People are being indicted. There are people's homes or hotel rooms and offices are being raided. People are being charged and convicted for providing false statements to the FBI. And let's not forget, we have the investigation notes from the FBI during the Clinton investigation, and Cheryl Mills as well as Huma Abedin, based on the evidence that we do have in clear documents and emails, their statements to the FBI do not seem to be truthful.
So You're saying, I mean, there in the Mueller investigation, there have been a number of different people that have pled out to sort of false statements to
Right.
investigators, which
Right.
can be a federal crime. So there's a number of them that have pled out to that. But you're saying that there's when it comes to the questioning and their statements during the Clinton email investigation, there were also a number of people that seem to have given some sort of false statements. Yeah.
Absolutely, and I don't mean to. I mean,
Yeah.
there are statements that, based on the evidence, appear to be as false as it can be.
Yeah.
But then also, what has come to light and what we have learned from the Clinton investigation, you had Secretary Clinton's attorneys, David Kendall, Cheryl Mills, I believe also Heather Samuelson, on conference calls with Platte River. This is pending our lawsuits. Mm-hmm. This is pending litigation in federal district court.
So you're saying they were doing these things when there were already requests for this information
Absolutely.
out there. Yeah.
Absolutely. And at this point, there were requests from Congress as well.
Okay.
For her emails, and we had active litigation where we were asking for Secretary Clinton's emails as to Benghazi or whatever else it may be. One of them was that I alluded to, her request to use smart devices or iPhones and iPads. So you had David Kendall, Cheryl Mills, I believe also Heather Samuelson, on a conference call with Platte River, and Platte River was the outfit that was securing the backups and the server for Secretary Clinton after she had left the State Department. This is back in March of 2015, after the news broke about her server. Mm-hmm. You had a conference call between them. Now, we don't know the contents of those calls because they're claiming attorney-client privilege, and we can talk about attorney-client privilege in a minute. So we don't know the content of that, but we do know we have pending lawsuits then. And then we also do know that David Kendall, I think I want to say maybe 2 days after the conference call, told the House committee that there are no other emails that have been stored from Secretary Clinton's tenure at the State Department. And then 3 days later, so March 25th was the first call, David Kendall informed Congress on March 27th that there are no other emails. And on March 31st, we do know from the logs from Platte River that her email, the servers were wiped clean. Bleach bit is what they call it.
Right.
And on March 31st, there was also another conference call.
So they're talking. We don't know exactly what they're talking about. There's all of these requests out there for this information. And
I imagine the discussion is not how do we get these emails to Congress and to Judicial Watch and to the public.
Yeah, especially not when they go ahead and use BleachBit to...
And I imagine it has more to do with the BleachBit process.
Yeah, right. Mm-hmm. Let's talk about attorney-client privilege. Because you just alluded to it, that it was asserted throughout the Clinton email investigation. Now, we've seen in the Special Counsel Mueller's investigation that I believe at least one other attorney before the most recent events had already sort of been compelled in various ways to provide information, this, that, and the other thing, sort of in an exception to the attorney-client privilege rule. And then, of course, we had President Trump's private attorney, like you said, having his home office raided following a referral from Special Counsel Mueller's office. So it seems that with the Mueller investigation, they're pushing the boundary on attorney-client privilege as much as they can and pushing the investigation as hard as they can. Now, how did that work during the Clinton email investigation? How was attorney-client privilege treated then?
I almost want to say that they probably asked him, do you want to raise the attorney-client privilege? That's how it was treated during the Clinton investigation. So you had Secretary Clinton's server and Secretary Clinton's use of her email at the center of this investigation. You have Cheryl Mills, who's her chief of staff, and you have Huma Abedin, who's her deputy chief of staff. Huma Abedin also had her own email account that she used for State Department work, and her email was also housed on the server. Cheryl Mills was counselor and chief of staff at the time that Secretary Clinton was the secretary. Upon her leaving, Secretary Clinton asked Cheryl Mills to be her private lawyer. So everything we communicate from now on is attorney-client privilege. Now, everything that they're talking about is not necessarily just what's happening now, but also with respect to what happened and the server that was in use at the time during her tenure at the State Department. So now they're claiming it's attorney-client privilege for the entire scope from like 2009 to the present. Everything that was discussed with Secretary Clinton and Cheryl Mills, right? And the other thing with respect to conflicts, Cheryl Mills is a material witness, and yet she's able to sit on Secretary Clinton's interview with the FBI and and act as her attorney. Now, this is after the FBI interviewed Cheryl Mills herself in the investigation. So the FBI is interviewing Cheryl Mills. She provides her answers. She knows what questions, are being asked, and then she gets to go to the next interview and act as the attorney of Mrs. Clinton during the investigation. I mean, the conflict, and the difference in the treatment in these two investigations. I mean, it's just it's night and day.
It's night and day. I think an easy way to sum it up is, Special Counsel Mueller's investigation is what it looks like when they're trying to get someone, and the Hillary Clinton investigation is what it looks like when they're doing everything they can to not. I mean,
it's about the end goal.
It's about the end goal. So what do
it's
you mean
not
by that?
about, because an investigation should be you follow the facts. You follow where the evidence leads you. You start asking questions with the person number one, person number two, and wherever the evidence leads you, that's where you go. And that's when you get, when you have investigations and where there's an integrity to the investigation that's being conducted. It's not partial. It's not driven by anybody's ambitions or by a certain outcome that you want the investigation to have. Here, however, you have, where do we want to end up? And what are we going to do to get there? We do not want to prosecute Secretary Clinton. Secretary Clinton, according to what many people thought, is going to be our next president.
Yeah.
So how do we get to that point? Well, we'll go ahead and hand out immunity deals. Well, we'll go ahead and let you act as her attorney pending in an active FBI investigation where both the attorney and Secretary Clinton were subjects of the investigation. That's where they wanted to end up with the investigation of Secretary Clinton. That's why you had the statement back in May before a number of the material witnesses had been interviewed. With respect to the Russian investigation, I think it's clear they want to end up with prosecutions, and they're going to use the full measure of subpoena power. And my goodness, they're going, attorney-client, oh well, we'll go ahead and look at these documents anyway.
And just like that. So I mean, it's all about sort of the end goal, and which by the way is, I mean, that's the exact wrong way to approach this, as you're saying. It's the exact wrong way to do this. You don't want to maintain sort of a faith in our justice system, in the FBI and the DOJ. There's got to be this idea that we go where the facts lead us, we follow the evidence, we open up investigations when there's evidence of a crime, we investigate it. But what you're saying is essentially what it looked like is we don't want to prosecute Hillary Clinton, so we're going to adjust our tactics so that it ends with no prosecution. We want to prosecute President Trump or his team, and so we're going to adjust our tactics that way. And what really should be happening in both instances is going where the facts lead us.
Impartial, and just.
Right. And you don't want to see disparities like this in major investigations. So I think we've covered a lot of ground here about sort of the different ways that attorney-client privilege played into it, the different the levels of seriousness when it came to false statements during the Clinton investigation, during the Trump investigation, different differences in the hardball tactics and not so much. So where do you kind of see it going from here? I know that with Judicial Watch we have a lot of different lawsuits still out, actually surrounding both investigations, because we're still getting Hillary Clinton emails. We've gotten 694 so far that she, in addition to she said she had turned them all over. We found 694 more that hadn't been. We have lawsuits into the trying to hold the Trump-Russia investigation accountable. So where do you kind of see things going from here as we continue to, search for facts, search for the truth, and get, kind of get to the bottom of both of these things?
Well, I think that's it. I think we continue to just search for facts and search for the truth. I think there is still very little known about the Attorney General's meeting with Bill Clinton during the investigation. We still have our case involving that. And like you say, there's a lot of information that still hasn't become available. So with respect to the Clinton investigation, I think the point, whatever requests we have and the lawsuits we have, we're going to continue to go through them. Litigation takes a very long time.
Yeah.
The case in front of Judge Lamberth, we do have an order for discovery. We are still waiting for him to approve how much discovery we can get. But, at the same time, what's important, and it's not part of this necessarily, this discussion, but how do we go back now and fix what Secretary Clinton did? How do we go back and create the universe of her federal records, of her emails while she was at the State Department? So that's one of the things that we're also working on. And with the investigation of special counsel, the Mueller investigation in Russia, I mean, we're just going to continue with our cases at this point. So
one final thing, because you brought up the Tarmac meeting.
Yes.
Loretta Lynch, which I think is still big because it's sort of a missing piece of the puzzle that we still don't really have an answer on, and I think this is a good thing to sort of close on, because I think it helps show sort of the double standard that exists between the two investigations. Loretta Lynch meeting with Bill Clinton in the midst of the Clinton investigation. I don't know how good of a comparison it is, but you're not going to see Robert Mueller meeting with the wife of one of his, targets in some secret meeting, off the books meeting, like
and the spouse of one of his targets, let's say, who has considerable power of persuasion.
Right.
Let's remember Bill Clinton was the president. Let's remember he was Loretta Lynch's former boss, and also Loretta Lynch was planning on continuing to work under Bill Clinton's spouse, under Hillary Clinton. So I think that's why it's hard to even find a similar comparison with that type of influence.
Right, because it almost doesn't exist, because the conflict of interest in having a secret meeting like that is so extreme that there really is no good comparison. That is going to probably be the gold standard in don't do stuff like this. Right. From now on, and you said we're still trying to get answers on that as well.
Yes, and I think what's interesting, the information we do have on that is the FBI and the government officials not responding with respect to what was said, but rather who leaked this. That was the immediate response when we filed this based on the records we got when we filed this lawsuit. Who leaked it? and which tells you that there was an intention about that meeting being secret.
So you're saying that when with this tarmac meeting between Lynch and Clinton in the midst of the presidential election, midst of the Clinton email investigation, our records show that their big concern wasn't about this obviously very conflicted meeting taking place, but more was just a concern about how do we do damage control and how do we find out who told.
And I think the how do we find out who told is very telling with respect to their intention of this being secret and not coming out and being public.
And as we close out here, what's important to remember is that a lot of the players from the Clinton email investigation were the same people that were involved in the Trump-Russia investigation, or at least in the genesis of it. And so when you see sort of the way that they acted in 2015 and 2016, with the knowledge that they then went on to influence a lot of things in 2016, 2017, and 2018, it is, something important, something that's worth pointing out. So,
yes, Peter Strzok
being front and center, and of course James Comey as well.
Right.
Well, Ramona, I think that was very enlightening. I think that we covered a lot of ground, and I think that really helped to show sort of the difference between the way that these two investigations were carried out. So thank you for lending your expertise there, and we'll continue to bring you back as we learn more.
Sure.
So, and thank you for joining us today for this latest edition of Inside Judicial Watch. Be sure to follow Judicial Watch on Facebook, on Twitter, on Instagram, on YouTube. Visit our website, judicialwatch.org, so that you can keep up with the very important work that attorneys like Ramona are doing, so that you can continue to follow along with our investigations. Until next time, for Inside Judicial Watch, I'm your host, Jerry Dunleavy. Thanks for joining us.